Good evening, everyone. I, Advocate Anshul Rana, along with Advocate Saksham Dudeja, welcome you all here for this session. Our today's topic is reviving traditions in legal practice. First of all, I would like to thank our Honorable Chief Justice, Mr. Sheel Nagu, for providing us with this infrastructure to conduct this wonderful session. There are certain practices that are followed in our legal profession since time immemorial. I want to share with you all one thing, that the idea of this topic was propounded by Honorable Mr. Justice H.S. Sidhu, former Chief Justice of this Honorable High Court. During his tenure, Lordship noticed that certain practices, like offering seat to a senior counsel, is slowly diminishing. And at times, young counsels, they even question that are we obliged to offer seat to senior counsels? We have today our esteemed panelists, Senior Advocate Manjeet Singh Khaira, Senior Advocate Shri Puran Singh Hundal, Senior Advocate Shri Gaurav Chopra, and Advocate Shri Abhimanyu Singh. As we all know, with their vast knowledge and experience, seniors in our profession are the custodians of wisdom and also the architects of mentorship. On that note, we would like to welcome our first speaker, on Sir Manjeet Singh Khaira, Senior Advocate. Sir has been an advocate for more than 60 years, out of which he has been designated Senior Advocate of Punjab Haryana High Court for 39 years. Sir is the only advocate who has advocated the cause of Punjab in all commissions since 1966, right from Shah Commission to Iradi Commission. Even Sarkaria Commission, it was again Sir who presented the memorandum on behalf of Shiromani Akali Dal. In 2020, Sir represented Amrit Kaur concerning the inheritance of the last ruler of Faridkot's estate. Sir has also been a very prominent figure in Punjab's political history. Sir, now we would like to know about your thoughts on diminishing practice of vacating seats in our courts for seniors as a mark of respect, and how can seniors mentor regularly the juniors and indulge in discussions with them? Over to you, sir.
Respect है ਜਿਹੜੀ ਉਹ ਅਰਨ ਕੀਤੀ ਜਾਂਦੀ ਹੈ, ਇਟਸ ਮਿਊਚੁਅਲ। ਸੀਨੀਅਰਸ ਅਗਰ ਜੂਨੀਅਰਸ ਨੂੰ ਕੰਸੀਡਰੇਟ ਹੋਣਗੇ ਔਰ ਉਹਨੂੰ ਵੈਲਕਮ ਕਰਨਗੇ ਤੇ ਜੂਨੀਅਰ ਵੀ ਰਿਸਪੈਕਟ ਦੇਣਗੇ। ਥੋੜ੍ਹਾ ਜਿਹਾ ਇੱਕ ਪ੍ਰੈਕਟਿਸ ਜਿਹੜੀ ਇੱਥੇ ਨਹੀਂ ਹੈ, ਸੁਪਰੀਮ ਕੋਰਟ 'ਚ ਹੈ, ਫਰੰਟ ਲਾਈਨ ਦੀਆਂ ਸੀਟਸ ਉਹਨਾਂ ਕੋਲ ਹੁੰਦੀਆਂ ਜਿਨ੍ਹਾਂ ਨੇ ਨੈਕਸਟ 2 ਕੇਸਿਸ ਆਰਗੂ ਕਰਨੇ, ਬਾਕੀ ਪਿੱਛੇ ਪੈਂਦੇ। ਸਾਡੇ ਰਿਵਾਜ ਪੈ ਗਿਆ ਜਿਹਦਾ 50 ਨੰਬਰ ਕੇਸ ਆ ਉਹ ਵੀ ਮੂਹਰੇ ਪੈ ਜਾਂਦਾ, ਅਤੇ ਉਹਦੇ ਨਾਲ ਜਿਹੜਾ ਇੰਟਰੈਕਸ਼ਨ ਵੀ ਹੈ ਨਾ, ਇਹ ਵੀ as they say, the effect be mutual understanding there, the way you look, the way you talk to people. ਹੁਣ ਸੋਸਾਇਟੀ 'ਚ ਇਹ ਘੱਟ ਹੀ ਗਿਆ ਕਿ ਵੱਡੇ ਦੀ ਰਿਸਪੈਕਟ ਫੈਮਲੀਜ਼ 'ਚ ਨਹੀਂ ਰਹੀ, ਬਾਹਰ ਕਿੱਥੋਂ ਹੋ ਜਾਓ। ਮਗਰ ਇਹ ਟੋਟਲ ਰੋਲਰ ਕੋਸਟਰ ਇਫੈਕਟ ਹੁੰਦਾ। ਆਪਾਂ ਬਲੇਮ ਨਹੀਂ ਕਰ ਸਕਦੇ ਕਿ ਵੀ ਜੇ ਯੰਗਸਟਰਸ ਮਿਸਬਿਹੇਵ ਕਰਦੇ ਆ ਜਾਂ ਯੰਗਸਟਰਸ ਨੂੰ ਰਿਸਪੈਕਟ ਨਹੀਂ ਰਹੀ। ਕੁਐਸਚਨ ਇਹ ਤਾਂ ਅਸੀਂ ਵੀ ਜੇ ਕੋਈ ਤੁਹਾਡੇ ਕੋਲ ਆ ਜਾਏ, ਮੈਂ ਇਸ ਤਰ੍ਹਾਂ ਕਰਦਾ ਰਿਹਾ, ਮੈਂ ਦੱਸ ਰਿਹਾ ਸੀ, ਮੇਰੇ ਕੋਲ ਕੋਈ ਯੰਗਸਟਰ ਆ ਜਾਏ ਫਾਈਲ ਲੈ ਕੇ, ਮੈਂ ਉਹਨੂੰ ਪਹਿਲਾਂ ਤਾਂ ਐਡਵਾਈਜ਼ ਕਰਨਾ ਵੀ ਦੇਖੀ ਕਿਤੇ ਕਲਾਇੰਟ ਨਾ ਲਿਆਈ। ਕਹਿੰਦਾ ਕਿਉਂ? ਮੈਂ ਕਿਹਾ ਤੇਰਾ ਜਾਂਦਾ ਰਹੂ। Nobody wants to engage a lawyer who is second rate. ਇਸ ਕਰਕੇ ਇੱਕ ਤਾਂ ਆਪਣੀ ਵਕਾਲਤ ਬਚਾਉਣ ਲਈ ਸੀਨੀਅਰ ਕੋਲ ਕਲਾਇੰਟ ਨਾ ਲੈ ਕੇ ਜਾਓ ਕਦੇ। ਦੂਸਰਾ, ਮੈਂ ਉਹਨੂੰ ਕੇਸ ਤਿਆਰ ਕਰਵਾਉਣਾ ਔਰ ਓਵਰ ਜਨਰਸ ਹੋ ਜਾਣਾ, ਕਿਤਾਬ ਵੀ ਦੇ ਦੇਣੀ ਵੀ ਆਹ ਕਿਤਾਬ ਲੈ ਜਾ, ਤੇਰੇ ਕੋਲ ਨਹੀਂ ਹੋਣੀ, ਪੜ੍ਹ ਲਈ। 3 ਵਾਰੀ ਐਕਸਪੀਰੀਅੰਸ ਹੋਇਆ ਵੀ ਨਾ ਉਹ ਆਇਆ ਅਤੇ ਨਾ ਕਿਤਾਬ ਆਈ। ਮੈਂ ਕਿਤਾਬ ਦੇਣੀ ਬੰਦ ਕਰਤੀ। ਇਹ ਇਸ ਕਰਕੇ ਦੱਸ ਰਿਹਾ ਕਿ ਉਹਨੇ ਵੀ ਕੁਛ ਨਹੀਂ ਗੇਨ ਕੀਤਾ, ਉਹ ਇੱਕ ਸੈੱਟ 'ਚੋਂ ਇੱਕ ਕਿਤਾਬ ਲਿਜਾ ਕੇ ਅਬਲਾ ਤੋਂ ਉਹਨੇ ਪੜ੍ਹੀ ਵੀ ਨਹੀਂ ਹੋਣੀ। ਜੇ ਪੜ੍ਹੀ ਵੀ ਉਹਨੇ, ਜੇ ਮੇਰੇ ਨਾਲ ਇੰਟਰੈਕਸ਼ਨ ਕਰਦਾ ਰਹਿੰਦਾ, ਉਹਨੂੰ ਘੱਟੋ ਘੱਟ ਆਪਣਾ ਕੇਸ ਤਿਆਰ ਕਰਨਾ ਹੀ ਸੌਖਾ ਹੋ ਜਾਂਦਾ। ਜਿਹੜੀ ਗੱਲ ਮੈਂ 15 ਮਿੰਟ ਸਮਝਾ ਦੇਣੀ, ਉਹ 2 ਦਿਨ ਲਾ ਕੇ ਸਮਝਦਾ, ਆਪ ਪੜ੍ਹਦਾ। ਸੋ ਇਹ ਮਿਊਚੁਅਲ ਹੈ। ਮਿਊਚੁਅਲ ਟਰਸਟ ਕ੍ਰੀਏਟ ਕਰਨਾ, ਮਿਊਚੁਅਲ ਰਿਸਪੈਕਟ ਕ੍ਰੀਏਟ ਕਰਨੀ। ਦੂਸਰਾ, ਪ੍ਰੋਫੈਸ਼ਨਲ ਐਥਿਕਸ ਬਹੁਤ ਹੀ ਮਿਟਦੇ ਜਾਂਦੇ। ਔਰ ਦੇਖੋ, ਤੁਸੀਂ ਪ੍ਰੋਫੈਸ਼ਨ 'ਚ ਆਏ ਹੋ, ਰੋਟੀ ਕਮਾਉਣ ਆਏ ਹੋ, ਕੋਈ ਪੁੰਨਦਾਨ ਤਾਂ ਕਰਨ ਆਏ ਨਹੀਂ, ਮਗਰ ਉਹਦੇ 'ਚ ਮਿਊਚੁਅਲੀ ਬੈਨੀਫੀਸ਼ੀਅਲ ਰਿਲੇਸ਼ਨਸ਼ਿਪ ਹੋਵੇ, ਕਲਾਇੰਟ ਨੂੰ ਵੀ ਓਨੈਸਟ ਸਰਵਿਸ ਮਿਲੇ, ਤੁਹਾਡੀ ਵੀ ਰੋਟੀ ਚੱਲੇ। ਦੋਨੇ ਇੱਕ ਵਨ ਵੇ ਟ੍ਰੈਫਿਕ ਨਹੀਂ ਹੋ ਸਕਦੀ। ਮਗਰ ਬਹੁਤ ਇੱਕ ਵੱਡੀ ਕਲਾਸ ਹੈ ਨਵੇਂ ਆਉਣ ਵਾਲੇ ਬੰਦਿਆਂ 'ਚ ਜਿਹੜੀ ਇਸ ਪ੍ਰਿੰਸੀਪਲ ਨੂੰ ਅਡਹੇਅਰ ਨਹੀਂ ਕਰਦੀ। ਮਗਰ ਐਟ ਦੀ ਸੇਮ ਟਾਈਮ ਮੈਂ ਦੇਖਦਾ ਬਈ ਨਵੇਂ ਜੱਜ ਵੀ ਬਣਦੇ ਆ, ਕਈਆਂ 'ਚ ਦੇਖਦੇ ਹਾਂ ਕਿ ਹੁਣ ਆਉਣ ਵਾਲੇ ਯੰਗਸਟਰ ਸਾਡੇ ਨਾਲੋਂ ਵੱਧ ਨੌਲੇਜ ਰੱਖਦੇ ਆ ਜਿਹੜੀ ਉਸ ਸਟੇਜ 'ਤੇ ਸਾਡੇ ਕੋਲ ਸੀ। ਇੱਕ ਤਾਂ ਐਜੂਕੇਸ਼ਨ ਦੇ ਸਟੈਂਡਰਡਸ ਬਦਲ ਗਏ। ਇੱਕ ਅਸੀਂ 50 ਈਅਰ ਡਾਈਜੈਸਟ, 15 ਈਅਰ ਡਾਈਜੈਸਟ, 5 ਈਅਰ ਡਾਈਜੈਸਟ, ਫਿਰ ਕਰੰਟ ਡਾਈਜੈਸਟ 'ਚ ਅਥਾਰਟੀਆਂ ਲੱਭਦੇ ਸੀ, ਹੁਣ ਕਲਿੱਕ ਆਫ ਏ ਬਟਨ ਯੂ ਗੈਟ ਇਟ। ਇਸ ਫੈਸਿਲਿਟੀ ਦਾ ਪੋਜ਼ਿਟਿਵ ਸੈਂਸ 'ਚ ਫਾਇਦਾ ਉਠਾਉਣਾ, ਇਹ ਹਰ ਇੱਕ ਇੰਡੀਵਿਜੂਅਲ 'ਤੇ ਆ। ਮੈਂ ਤਾਂ ਇਹ ਕਹਿੰਦਾ ਬਈ ਇਹ ਪ੍ਰੋਫੈਸ਼ਨ ਇਹੋ ਜਿਹਾ ਡੌਗ ਈਟਸ ਡੌਗ ਵਾਲੀ ਗੱਲ ਹੈ। ਇੱਕ ਤਾਂ ਸਾਰੇ ਇੱਕ ਦੂਜੇ ਦੇ। ਦੂਸਰਾ, ਦੀ ਵੈਰੀ ਫਸਟ ਡੇ ਯੂ ਮੇ ਫੇਸ ਦੀ ਸੀਨੀਅਰ ਮੋਸਟ। ਕਿਸੇ ਹੋਰ ਪ੍ਰੋਫੈਸ਼ਨ 'ਚ ਇਹ ਨਹੀਂ ਕਿ ਤੁਹਾਡੇ ਐਕਸਪੀਰੀਅੰਸ, ਤੁਹਾਡੀ ਸਟੈਂਡਿੰਗ ਕਿਸੇ ਵੀ ਕੰਸੀਡਰੇਸ਼ਨ 'ਚ ਹੋਏ। ਚਾਹੇ ਤੁਸੀਂ ਸੀਨੀਅਰ ਮੋਸਟ ਹੋ, ਚਾਹੇ ਜੂਨੀਅਰ ਮੋਸਟ ਹੋ, ਗੱਲ ਅਖੀਰ ਉਹਨਾਂ ਫੈਕਟਸ 'ਤੇ, ਉਸ ਸਲਾਹ ਦੇ ਡਿਸਕਸ਼ਨ 'ਤੇ ਆਉਣੀ ਹੈ। ਮਗਰ ਅਸੀਂ ਗਰੋ ਕੀਤਾ ਉਸ ਫੇਜ਼ 'ਚ ਜਦੋਂ ਮੋਸਟ ਆਫ ਦੀ ਜੱਜਿਸ ਜੂਨੀਅਰਸ ਨੂੰ ਗਾਈਡ ਕਰਦੇ ਸੀ ਕੋਰਟ 'ਚ ਵੀ। ਮਗਰ ਐਟ ਦੀ ਸੇਮ ਟਾਈਮ ਜੇ ਕੋਈ ਜੂਨੀਅਰ ਜਾਂ ਕੋਈ ਵੀ ਮਿਸਸਟੇਟ ਕਰੇ ਫੈਕਟ, ਇਸ ਕਰਕੇ ਇਹ ਚੰਗਾ ਇਸ ਤਰ੍ਹਾਂ ਮੀਟ ਕਰਕੇ ਆਪਾਂ ਇੰਟਰੋਸਪੈਕਟ ਕਰੀਏ ਅਤੇ ਗੱਲ ਕਹਿ ਦੇਣੀ ਬੜੀ ਸੌਖੀ ਆ, ਟੂ ਲਿਵ ਅਪ ਟੂ ਇਟ। ਮੈਂ ਜ਼ਰੂਰ ਆਫਰ ਕਰਦਾ, ਕਿਸੇ ਜੂਨੀਅਰ ਨੇ ਕੋਈ ਕੇਸ ਸਮਝਣਾ ਹੋਵੇ, ਤਿਆਰ ਕਰਾਉਣਾ ਹੋਵੇ, ਮੇਰਾ ਚੈਂਬਰ ਨੰਬਰ 23 ਆ, ਕਦੇ ਆ ਜਾਓ। ਕਿਤਾਬ ਨਹੀਂ ਦੇਣੀ ਮੈਂ, ਉਹ ਮੇਰਾ ਮਾੜਾ ਐਕਸਪੀਰੀਅੰਸ। ਹੈਲਪ ਕਰੂੰਗਾ ਤਿਆਰ ਕਰਨ 'ਚ, ਸਮਝਣ 'ਚ, ਪ੍ਰੋਫੈਸ਼ਨਲ ਲਾਈਫ 'ਚ ਗਾਈਡ ਕਰੂੰ, ਇਹਦੇ ਲਈ ਮੈਂ ਓਪਨ ਹੈ। ਅਤੇ ਉਹਦੇ 'ਚ ਇੱਕ ਹੋਰ ਫੈਕਟਰ ਸਮਝ ਲਓ ਕਿ ਹੁਣ ਬਹੁਤਾ ਤੁਰਿਆ ਫਿਰੇ ਨਹੀਂ ਜਾਂਦਾ। ਕੇਸ ਵੀ ਜਿਹੜੇ ਪੁਰਾਣੇ ਪੈਸੇ ਲਏ ਆ, ਉਹ ਮੋਰੈਲਿਟੀ ਮਾਰਦੀ ਆ ਵੀ ਪੈਸੇ ਲਏ ਹੋਏ ਆ ਤਾਂ ਕੇਸ ਨਾ ਕਰੋ, ਵਰਨਾ ਕੋਈ ਬਹੁਤਾ ਸ਼ੌਕ ਨਹੀਂ ਰਿਹਾ।
Thank you, sir. That was very insightful. Now we would like to welcome our second speaker, Senior Advocate Shri Puran Singh Hundal, a man with countless achievements and an undying urge to do more. A designated Senior Advocate of our High Court since year 2008. Sir's in-depth knowledge of criminal law and relentless nature have made him a person of great stature. Sir is one of the senior members of our bar and has been engaged in various high-profile cases throughout his career, like Nirankari case, Operation Blue Star, and Ludhiana bank robbery case. Sir was a public prosecutor, but in 1975, when emergency was declared, Sir left his post and started his own practice. Sir, from your own years of experience, what would be the traditional courtesies that you would like to pass on to both the senior hierarchy and the upcoming advocates, and the importance of passing wisdom informally to young lawyers?
ਹਾਂ, ਮੈਂ ਪਹਿਲਾਂ ਜਿਸ ਤਰ੍ਹਾਂ ਤੁਸੀਂ ਸਾਰੇ ਜਾਣਦੇ ਹੋ ਕਿ ਮੈਂ ਘਰ ਵੀ ਸਾਰਾ ਦਿਨ ਜਦੋਂ ਮੈਂ ਘਰ ਹੋਵਾਂ ਬਾਹਰ ਹੋਵਾਂ ਮੈਂ ਹਰ ਵੇਲੇ ਹੱਸਦਾ ਰਹਿੰਦਾ। ਹਿਊਮਰ ਇਜ਼ ਮਾਈ ਕੱਪ ਆਫ ਟੀ। ਇਹਨਾਂ ਨੇ ਕਿਤਾਬਾਂ ਦੀ ਗੱਲ ਕੀਤੀ ਵੀ ਮੈਂ ਕਿਤਾਬ ਕਿਸੇ ਨੂੰ ਨਹੀਂ ਦਿੰਦਾ। ਉਹਨਾਂ ਬਾਰੇ ਇੱਕ ਬੜੇ ਸੀਨੀਅਰ ਫਰੈਂਡ ਨੇ, ਕਿਤਾਬਾਂ ਦੇ ਬੜੇ ਸ਼ੌਕ ਹੈ, ਮੈਨੂੰ ਵੀ ਨਵੀਆਂ ਕਿਤਾਬਾਂ ਪੜ੍ਹਨ ਦਾ ਬਹੁਤ ਸ਼ੌਕ ਹੈ, ਖਰੀਦ ਕੇ ਪੜ੍ਹੀ ਦੀਆਂ। ਕਿਤਾਬਾਂ ਬਾਰੇ ਕਿਹਾ ਹੈ ਕਿ ਜਿਹੜਾ ਕਿਤਾਬ ਕਿਸੇ ਨੂੰ ਕੋਈ ਉਧਾਰੀ ਦਿੰਦਾ ਉਹ ਮੂਰਖ ਹੁੰਦਾ ਹੈ, ਜਿਹੜਾ ਉਧਾਰੀ ਲੈ ਕੇ ਵਾਪਸ ਕਰਦਾ ਉਹ ਮਹਾਂ ਮੂਰਖ ਹੁੰਦਾ। ਜਿੱਥੇ ਕਿਤਾਬ ਚੱਲ ਜਾਏ ਉੱਥੇ ਵਾਪਸ ਨਹੀਂ ਮੁੜ ਕੇ ਆਉਂਦੀ। ਸਾਡੀ ਵੀ ਲਾਇਬ੍ਰੇਰੀ 'ਚ ਬਹੁਤ ਸਾਰੀਆਂ ਘੱਟ ਹੈ। ਐਨੀਵੇ, ਜਿੱਥੋਂ ਤੱਕ ਅੱਜ ਦੇ ਇਸ ਵਿਚਾਰ ਵਟਾਂਦਰੇ ਦਾ ਸੰਬੰਧ ਹੈ, ਥੋੜ੍ਹਾ ਜਿਹਾ ਮੈਂ ਡਿਫਰ ਕਰਾਂਗਾ, ਬਹੁਤਾ ਡਿਫਰ ਕਰ ਨਹੀਂ ਸਕਦਾ। ਮੇਰੇ ਬੜੇ ਹੀ ਸਤਿਕਾਰਯੋਗ ਨੇ, ਸਾਡਾ ਬੜਾ ਬਣਦੀ ਆਪਸ ਵੀ, ਮੈਂ ਇਹਨਾਂ ਨੂੰ ਸਾਰਾ ਜਾਣਦਾ। ਜਦੋਂ ਆਪਾਂ ਇਹ ਕਰ ਦਈਏ ਕਿ ਹੁਣ ਉਹ ਗੱਲਾਂ ਨਹੀਂ ਰਹੀਆਂ, ਜਿਹੜਾ ਮਨੁੱਖ ਇਹ ਗੱਲ ਕਰਨ ਲੱਗ ਪਿਆ ਕਿ ਜੀ ਬਹੁਤ ਚੰਗਾ ਹੁੰਦਾ ਸੀ, ਹੁਣ ਆਹ ਘਾਟਾ ਹੋ ਗਿਆ, ਹੁਣ ਐਂ ਹੋ ਗਿਆ, ਉਹ ਸਮਝੋ ਵੀ ਉਹ ਬੁੱਢਾ ਹੋ ਰਿਹਾ।
ਸ਼ੱਕ ਵੀ ਕੀ ਹੈ
ਨਾ, ਮੈਂ ਇਹਨੂੰ ਹੋਰ ਤਰ੍ਹਾਂ ਪੁੱਟ ਕਰਦਾ। ਸਿਸਟਮ ਡਿਟੀਰੀਓਰੇਟ ਨਹੀਂ ਹੋ ਰਿਹਾ, ਸਿਸਟਮ ਬਦਲ ਰਿਹਾ। ਤੁਸੀਂ ਸਾਲਾਂ ਦਾ ਕਿੰਨਾ ਫਰਕ ਪੈਣਾ, ਸਾਇੰਸ ਦਾ ਕਿੰਨਾ ਫਰਕ ਪਿਆ, ਇਨਫੋਰਮੇਸ਼ਨ ਟੈਕਨੋਲੋਜੀ ਨੇ ਕਿੰਨੀ ਚੇਂਜ ਲਿਆਂਦੀ ਹੈ। ਕਿਸੇ ਨੇ ਮੇਰੇ ਵਰਗੇ ਨੂੰ ਕਹਿ ਦਿੱਤਾ ਮਿਸਟਰ ਸੋ ਐਂਡ ਸੋ ਯੂ ਆਰ ਗੈਟਿੰਗ ਓਲਡਰ, ਕਹਿੰਦਾ ਨੋ ਆਈ ਐਮ ਨਾਟ ਗੈਟਿੰਗ ਓਲਡਰ, ਆਈ ਐਮ ਗੈਟਿੰਗ ਬੈਟਰ। ਆਪਾਂ ਇਹ ਨਹੀਂ ਕਹਾਂਗੇ ਵੀ ਇਸ ਰਿਲੇਸ਼ਨ ਦੇ ਵਿੱਚ ਡਿਟੀਰੀਓਰੇਸ਼ਨ ਆ ਰਹੀ ਹੈ। ਮੈਂ ਇਹਨੂੰ ਹੋਰ ਤਰ੍ਹਾਂ ਪੁੱਟ ਕਰਾਂਗੇ ਕਿ ਰਿਲੇਸ਼ਨ ਵਿੱਚ ਚੇਂਜ ਆ ਰਹੀ ਹੈ। ਇਹ ਤਾਂ ਅੱਜ ਬੜਾ ਥੋੜ੍ਹਾ ਸਮਾਂ, ਵੱਡਾ ਸਮਾਂ ਲੈ ਕੇ ਗੱਲ ਕਰਨ ਵਾਲੀ ਹੈ। ਇਹਦੇ ਕਈ ਕਾਰਨ ਹੋ ਸਕਦੇ ਹੈ ਵੀ ਕਿਉਂ ਜਿਹੜੀ ਚੇਂਜ ਵੀ ਹੈ ਇਹ ਚੰਗੇ ਪਾਸੇ ਚੇਂਜ ਹੈ ਕਿ ਇਹ ਮਾਈਨਸ ਪਾਸੇ ਚੇਂਜ ਹੈ, ਇਹ ਸਾਨੂੰ ਸੋਚਣਾ ਪਏਗਾ। ਅਸਲ 'ਚ ਜਦੋਂ ਦੀ ਇਹ ਮੈਂ ਚਾਰਲਸ ਡਾਰਵਿਨ ਦੀ ਪੜ੍ਹੋ ਤੁਸੀਂ ਐਵੋਲਿਊਸ਼ਨ ਆਫ ਲਾਈਫ ਥਿਊਰੀ, ਜਦੋਂ ਇਸ ਸੰਸਾਰ 'ਤੇ ਕੀੜੇ ਮਕੌੜੇ ਤੋਂ ਬੰਦਾ ਬਣਿਆ, ਆਪਣੀ ਲੋੜ ਮੁਤਾਬਕ ਸੋਸ਼ਲ ਕਿਉਂ ਅਸੀਂ, ਬੰਦੇ ਨੂੰ ਕਿਹਾ ਜਾਂਦਾ ਮੈਨ ਇਜ਼ ਅ ਸੋਸ਼ਲ ਐਨੀਮਲ, ਕਿਉਂ ਕਿਹਾ ਜਾਂਦਾ? ਅਸੀਂ ਆਪਾਂ ਲੋੜਾਂ ਦੇ ਬੱਝੇ ਸਾਂ। ਘਰ ਵੱਖਰੇ ਵੱਖਰੇ ਬਣਾ ਕੇ ਵੀ ਰਹਿ ਸਕਦੇ ਹਾਂ। ਪਿੰਡ ਇਕੱਠਾ ਕਿਉਂ ਹੁੰਦਾ ਹੈ, ਸ਼ਹਿਰ ਇਕੱਠਾ ਕਿਉਂ ਹੁੰਦਾ ਹੈ? ਇੱਕ ਦੂਜੇ ਤੋਂ ਸਾਨੂੰ ਸਿਕਿਉਰਿਟੀ ਹੁੰਦੀ ਹੈ। ਚਾਰ ਘਰ ਇਕੱਠੇ ਹੋ ਗਏ। ਜਿਉਂ-ਜਿਉਂ ਸਾਡੇ ਕੋਲ ਸੁੱਖ ਦੇ ਸਾਧਨ ਵੱਧਦੇ ਜਾਂਦੇ ਹੈ, ਪੈਸੇ ਦੀ ਬਹੁਤਾਤ ਹੋਈ ਜਾਂਦੀ ਹੈ, ਜਿਹੜਾ ਫਾਰਮ ਹਾਊਸ ਜਾ ਕੇ ਬਣਾਉਂਦਾ ਉਹਦਾ ਮਤਲਬ ਇਹ ਹੁੰਦਾ ਕਿ ਉਹਦੇ ਕੋਲ ਪੈਸੇ ਬਹੁਤ ਜ਼ਿਆਦਾ, ਉਹ ਗਾਰਡ ਵੀ ਰੱਖ ਸਕਦਾ ਰਾਤ ਨੂੰ। ਸਿਕਿਉਰਿਟੀ ਇਸ ਚੀਜ਼ 'ਚ ਹੈ ਵੀ ਤੁਸੀਂ ਜ਼ਰੂਰ ਚੰਗੀ ਕਾਲੋਨੀ 'ਚ ਕਿਸੇ ਰਹਿ ਲਓ, ਸੁਸਾਇਟੀ ਦੇ ਤੌਰ 'ਤੇ ਕਿਸੇ ਪਿੰਡ ਵਿੱਚ ਜਾਂ ਸ਼ਹਿਰ 'ਚ ਲੋੜ ਦੀ ਹੁੰਦੀ ਹੈ। ਜਦੋਂ ਲੋੜ ਜਿਹੜੀ ਨਾ ਕਾਰ ਲੋੜ ਦੀ ਮਾਂ ਹੁੰਦੀ ਹੈ, ਲੋੜ ਹੋਵੇ ਤਾਂ ਸਾਰਾ ਕੁਝ ਹੁੰਦਾ। ਸੋ ਇੱਥੋਂ ਅੱਗੇ ਚੱਲਦੀ ਹੈ ਵੀ ਸਾਡੇ ਇਹ ਜਿਹੜੇ ਸੰਬੰਧ ਨੇ, ਇਹਨੂੰ ਗੱਲ ਨੂੰ ਸ਼ਾਰਟ ਕਰੀਏ, ਇਹ ਮਿਊਚੁਅਲ ਹੈ। ਪੰਜਾਬ ਦੇ ਪਿੰਡਾਂ ਦੇ 'ਚ ਇੱਕ ਅਖਾਣ ਹੈ ਵੀ ਖੂਹ ਦੇ ਵਿੱਚ, ਹੁਣ ਤਾਂ ਖੂਹ ਰਹਿ ਹੀ ਨਹੀਂ ਹੋ ਸਕਦਾ, ਤੁਹਾਡੇ ਜੋ ਕਈਆਂ ਨੇ ਦੇਖੇ ਵੀ ਨਾ ਹੋਣ। ਖੂਹ ਦਾ ਪਤਾ ਜ਼ਰੂਰ ਹੈ ਵੀ ਖੂਹ ਕੀ ਹੁੰਦਾ। ਕਿਸੇ ਖੂਹ ਦੇ ਕੋਲ ਜਾ ਕੇ ਦੇਖਿਓ, ਆਵਾਜ਼ ਮਾਰੋਗੇ ਕਿ ਗੂੰਜ ਆਏਗੀ। ਤਾਂ ਪੰਜਾਬ ਦੇ ਵਿੱਚ ਅਖਾਣ ਬਣੀ ਕਿ ਖੂਹ ਦੇ ਵਿੱਚ ਜਿਸ ਤਰ੍ਹਾਂ ਦੀ ਆਵਾਜ਼ ਮਾਰੋਗੇ ਉਸ ਤਰ੍ਹਾਂ ਦੀ ਆਵਾਜ਼ ਉੱਥੋਂ ਵਾਪਸ ਆਏਗੀ। ਮਤਲਬ ਹੈ ਕਿ ਜਿਸ ਤਰ੍ਹਾਂ ਦਾ ਬਿਹੇਵੀਅਰ ਜਾਂ ਕੰਡਕਟ ਤੁਸੀਂ ਕਿਸੇ ਨਾਲ ਕਰੋਗੇ, ਉਹ ਵੀ ਤੁਹਾਡੇ ਨਾਲ ਉਸੇ ਤਰ੍ਹਾਂ ਕਰੇਗਾ। ਕਹਿਣ ਦਾ ਭਾਵ ਇਹ ਹੈ ਕਿ ਜੇ ਤੁਸੀਂ ਜਿੰਨੀ ਕਿਸੇ ਨੂੰ ਇੱਜ਼ਤ ਦੇਵਾਂਗੇ, ਜਿਹੜਾ ਮੈਂ ਜ਼ਾਤੀ ਤੌਰ 'ਤੇ ਕਰਦਾ, ਜਿਹੜੇ ਸਾਰੇ ਐਡਵੋਕੇਟਸ ਨੂੰ ਕਰਨਾ ਚਾਹੀਦਾ, ਮੇਰਾ ਇਹ ਸ਼ਾਇਦ ਤੁਹਾਡੇ 'ਚੋਂ ਕਿਸੇ ਨੂੰ ਵਾਹ ਪਿਆ ਵੀ ਹੋਵੇ। ਕਈ ਵਾਰ ਜੱਜ ਨਾ ਇਸ ਤਰ੍ਹਾਂ ਹੋ ਜਾਂਦਾ, ਸਾਡੇ ਜੱਜ ਸਾਹਿਬਾਨ ਵੀ ਨਵੇਂ ਮੁੰਡੇ ਨੂੰ ਕਈ ਝਿੜਕ ਦਿੰਦੇ ਆ। ਇੱਕ ਦੋ ਵਾਰ ਮੈਨੂੰ ਮਹਿਸੂਸ ਹੋਇਆ, ਦੋ ਚਾਰ ਵਾਰ ਹੋਇਆ ਵੀ ਮੈਂ ਉੱਠ ਕੇ ਕਹਿੰਦਾ ਜੱਜ ਸਾਹਿਬ ਨਹੀਂ, ਇਹ ਨਵੇਂ ਆ, ਇਹਨਾਂ ਨੂੰ ਤੁਸੀਂ ਇਸ ਤਰ੍ਹਾਂ ਨਾ ਕਰੋ। ਮੈਂ ਇੰਟਰਫੀਅਰ ਕਰਦਾ ਹਮੇਸ਼ਾ। ਦੂਸਰੀ ਇਹ ਹੁੰਦੀ ਹੈ ਜਦੋਂ ਸਪੋਜ਼ ਕੋਈ ਐਡਵੋਕੇਟ ਹੈ, ਉਹ ਜੱਜ ਮੰਨ ਨਹੀਂ ਰਿਹਾ, ਜੱਜਾਂ ਦਾ ਤੁਲਾ ਤਿਆਰ ਹੋ ਕੇ ਨਹੀਂ ਆਇਆ, ਤਾਂ ਮੈਂ ਕਈ ਵਾਰ ਜੇ ਮੈਨੂੰ ਪਤਾ ਹੋਵੇ ਉਸ ਪੁਆਇੰਟ ਦਾ, ਤਾਂ ਮੈਂ ਉਹਦਾ ਕੋਟ ਖਿੱਚ ਕੇ ਮਾੜਾ ਜਿਹਾ ਮੈਂ ਹੌਲੀ ਜਿਹੀ ਕਹਿਣਾ ਹੁੰਦਾ ਕਿ ਤੇ ਜਜਮੈਂਟਾਂ ਤੇਰੀ ਫੇਵਰ 'ਚ ਹੈਗੀ, ਹੁਣ ਤਰੀਕ ਲੈ ਲਓ, ਅਤੇ ਜੇ ਜਜਮੈਂਟਾਂ ਨਹੀਂ ਕਿ ਮੈਨੂੰ ਟੈਲੀਫੋਨ ਕਰ ਲਿਓ। ਇਸ ਤਰ੍ਹਾਂ ਦਾ ਜਿਹੜਾ ਕੰਮ ਹੈ ਗਿਵ ਐਂਡ ਟੇਕ, ਮੈਨੂੰ ਸਾਰੀ ਤਰ੍ਹਾਂ ਦੀ ਇਸ ਕਰਕੇ ਮਿਲਦੀ ਹੈ ਕਿ ਮੈਂ ਜਦੋਂ ਸਵੇਰੇ ਵੀ ਘਰੋਂ ਨਿਕਲਦਾ, ਇੱਥੇ ਆਉਣਾ, ਸਾਰਿਆਂ ਨੂੰ ਮੈਂ ਛੇੜ ਛਾੜ ਕੇ ਲੰਘਣਾ, ਹਰ ਇੱਕ ਨੂੰ ਬੋਲ ਕੇ, ਨਵੇਂ ਨੂੰ ਪੁਰਾਣੇ ਨੂੰ, ਇਸ ਤਰ੍ਹਾਂ। ਸੋ ਇਹ ਗਿਵ ਐਂਡ ਟੇਕ ਹੈ। ਸਾਨੂੰ ਇਹ ਕਿ ਲੋਡ ਕਾਰਡ ਦੀ ਮਾਂ ਇਸ ਤਰ੍ਹਾਂ ਹੁੰਦੀ ਹੈ ਕਿ ਜਦੋਂ ਕਿਤਾਬਾਂ ਹੁੰਦੀਆਂ ਸੀ ਅਤੇ ਇੱਕ ਡਿਸਐਡਵਾਂਟੇਜ ਸੀ ਨਵੇਂ ਐਡਵੋਕੇਟਸ ਨੂੰ ਕਿ ਉਹਨਾਂ ਕੋਲ ਕਿਤਾਬਾਂ ਖਰੀਦਣ ਨੂੰ ਪੈਸੇ ਨਹੀਂ ਸੀ ਹੁੰਦੇ, ਜਾਂ ਇਹ ਨਹੀਂ ਵੀ ਪੈਸੇ ਨਹੀਂ ਹੁੰਦੇ, ਚੰਗੇ ਘਰਾਂ ਦੇ ਮੁੰਡੇ ਕੋਲ ਸਭ ਕੁਝ ਹੁੰਦਾ ਹੈ। ਉਦੋਂ ਕਿਤਾਬਾਂ ਦਾ ਇਹ ਹੁੰਦਾ ਸੀ ਵੀ ਜੋ ਤੁਸੀਂ ਲਾਅ ਕੀਤਾ, ਜਿਸ ਤਰ੍ਹਾਂ ਮੈਂ 68 'ਚ ਲਾਅ ਕੀਤਾ, ਅੱਜ ਤੋਂ ਸਮਝ ਲਓ ਕਿੰਨੇ 57 ਈਅਰਸ ਹੋ ਗਏ। ਤਾਂ ਮੈਂ ਉਦੋਂ ਤੋਂ ਜਿਹੜੀਆਂ ਕਿਤਾਬਾਂ ਕ੍ਰਿਮਨਲ ਲਾ ਜਰਨਲ ਮੈਂ ਉਦੋਂ ਲੈਣਾ ਸ਼ੁਰੂ ਕਰਤਾ ਸੀ। ਕਿਤਾਬਾਂ ਹੁੰਦੀਆਂ ਸੀ ਸੀਨੀਅਰ, ਹੁਣ ਵਰਗੀ ਇੰਟਰਨੈਸ਼ਨਲ ਜਿਹੜੀ ਨੌਲੇਜ ਹੈ ਸਾਨੂੰ ਤੁਹਾਡੇ ਟਿਪਸ 'ਤੇ ਹੈ ਲੈਪਟਾਪ ਦੇ ਵਿੱਚ, ਉਹ ਨਹੀਂ ਸੀ ਹੁੰਦੀ। ਸੋ ਕਿਤਾਬਾਂ ਹੁੰਦੀਆਂ ਸੀ, ਉਹ ਡਿਪੈਂਡ ਕਰਦੇ ਸੀ ਸੀਨੀਅਰ ਐਡਵੋਕੇਟਸ ਨੂੰ। ਸੀਨੀਅਰ ਐਡਵੋਕੇਟਸ ਕੋਲ ਜਾਣਾ ਜੀ, ਸਾਨੂੰ ਇੱਥੇ ਜੱਜਮੈਂਟ ਦੱਸ ਦਿਓ। ਕਿਤਾਬਾਂ ਵਕੀਲ ਜਿੱਦਾਂ ਇਹਨਾਂ ਕਿਹਾ ਵੀ ਉਹਨਾਂ ਨੂੰ ਕਿਤਾਬਾਂ ਵੀ ਦਿਖਾ ਦਿੱਤੀਆਂ ਸੀ, ਉਹਨਾਂ ਨੂੰ ਜੱਜਮੈਂਟਾਂ ਵੀ ਦੱਸਦੀਆਂ ਸੀ। ਹੁਣ ਅਸਲ ਨਵੇਂ ਜਿਸ ਤਰ੍ਹਾਂ ਟਾਈਮ ਬਦਲਦਾ, ਜਿੱਦਾਂ ਮੈਂ ਕਹਿੰਦਾ ਕਿ ਚੇਂਜ ਹੈ, ਇਹ ਡਿਟੀਰੀਓਰੇਸ਼ਨ ਨਹੀਂ ਹੈ, ਇਟਸ ਚੇਂਜ। ਚੇਂਜ ਹੋਣਾ ਇਹ ਹੋਇਆ ਕਿ ਨਵੇਂ ਐਡਵੋਕੇਟਸ ਨੂੰ ਕੋਈ ਪੁਆਇੰਟ ਲੱਗਦਾ, ਉਹ ਸਾਥੋਂ ਪੁੱਛਣ ਤੋਂ ਪਹਿਲਾਂ ਉਹ ਇੱਕ ਬਟਨ ਦੱਬਦੇ ਤੋਂ ਸਾਰੀ ਨੌਲੇਜ ਆ ਜਾਂਦੀ ਹੈ। ਸੋ ਇਹ ਜਿਹੜੀ ਲੋਡ ਕਾਰਡ ਦੀ ਮਾਂ ਹੈ, ਉਦੋਂ ਸਾਡੇ ਤੋਂ ਡਿਪੈਂਡੈਂਟ ਨਹੀਂ ਰਹੇ। ਪਰ ਫਿਰ ਵੀ ਫਰਕ ਇਹ ਪੈਂਦਾ ਹੈ, ਜਿਉਂ ਬੰਦੇ ਕਿਸੇ ਦੇ ਬੰਦੇ ਵੀ ਸਾਡੇ ਆਮ ਸਮਾਜ ਵਿੱਚ ਰਹਿੰਦੇ ਆ। ਮੇਰਾ ਤਜਰਬਾ ਇਹ ਹੈ, ਜਦੋਂ ਕਿਸੇ ਬੰਦੇ ਕੋਲ ਪੈਸੇ ਜ਼ਿਆਦਾ, ਉਹ ਕੋਈ ਸੁੱਖ ਸਾਧਨ ਜ਼ਿਆਦਾ ਹੋ ਜਾਂਦੇ ਆ, ਫਿਰ ਉਹ ਕਿਸੇ ਦੇ ਡਿਪੈਂਡੈਂਟ ਨਹੀਂ ਰਹਿੰਦਾ, ਫਿਰ ਉਹ ਲੋਕਾਂ ਦੀ ਇੱਜ਼ਤ ਕਰਨੀ ਘੱਟ ਕਰ ਦਿੰਦਾ। ਸੋ ਮੇਰਾ ਕਹਿਣ ਦਾ ਭਾਵ ਹੈ ਗਿਵ ਐਂਡ ਟੇਕ ਹੈ। ਸਾਨੂੰ ਵੀ ਬਿਹੇਵ ਕਰਨਾ ਚਾਹੀਦਾ ਤਾਂ ਕਿ ਜਿੱਦਾਂ ਅਸੀਂ ਉਹਨਾਂ ਕੋਲ ਚਾਹੁੰਦੇ ਹਾਂ। ਥੈਂਕ ਯੂ ਵੈਰੀ ਮੱਚ।
Yes, sir. Thank you, sir. Thank you, sir. That was very insightful. Now I would like to welcome our third speaker, Senior Advocate Shri Gaurav Chopra ji. Sir has been an alumni of NLU Bhopal and was designated as a Senior Advocate in the Honorable Punjab and Haryana High Court in the year 2021 and has been the Standing Counsel for Punjab and Haryana High Court since 2007. Sir has been beautifully leading his father's legacy, Shri Ravindra Chopra ji, who was also a senior advocate and who was a former president of this bar association. He joined practice with his father in the year 2003, but Sir demise took place in the same year, so he carried that very legacy which was left by him and even now had made it bigger. I still can recall his article in which he said that nepotism is an exaggerated concept, but your hard work will determine whether you will take up in the legal profession or not, which Sir has proven his own journey with this. Now I would like to invite Shri Gaurav Chopra ji to say a few words on the topic.
Saksham, I must compliment you that all of you have done your research very well on the speakers. In fact, it's very enlightening. I have a few things to share. I have heard the speakers before me. I have noticed one thing. Since the time I got designated in May 2021, I have never had or never felt any experience or had any such run-in where a younger member of the bar, when I've entered a courtroom and that younger member of the bar is seated, has never gotten up and offered his or her seat to me. I have never noticed it. And that's a compliment that I have to give to the younger members of the bar. Whether they have learned these etiquettes, see, 9 out of 10 people maintain that etiquette. That's a wonderful quality that we have. Now, whether they have learned this from observing their seniors, how they respond to their seniors, is for them to judge. I'll give you an example. I went to the Supreme Court last year. There was a matter, and I was appearing in court number 2 before a bench headed by Justice Gavai. And so there were two seniors, and I was on caveat along with another senior from the Delhi High Court. I'm not taking his name, but he was older than me in the profession in terms of age. So as a matter of etiquette, I walked to the stand and I stood to his right. That's how you basically do, as if there is a young lawyer standing next to a senior lawyer. Now that's the etiquette that we have to give, that's the regard that we have to give. Even though seniors in law are equal, the fact of the matter is that this is the regard that we have to give, because that is what we learned from our seniors. Very nice of him when he told me that, Gaurav, if you are the one who's leading, please come to my left. Please lead. And that's when I came to the left and I addressed the arguments. We won that matter as a different matter, number one. Number two, it's very embarrassing when we enter a courtroom, because generally it's the men who have to always give a seat and offer a seat to a lady lawyer. This is one profession where the lady lawyers give you that regard, give you that respect, they offer their seats. It's very embarrassing. But I say this with a great sense of happiness that even this etiquette dehoes whatever happens between a man and a woman and how we are supposed to behave inter se with each other. This profession, multiple times it's happened without fail. And I have to compliment, and I believe everyone out here would have observed this and would agree with me also. Number one. Number two, there was this one topic that you had highlighted in your chart that you had shared. Yes. And one such thing that I had noticed was that technology is a very, very big leveler. The time when I joined the profession in 2003, we did not have the advantage of having softwares. We did not have the advantage of having these computer-generated systems. And we used to do all our research. Now, there was a very big disadvantage for a younger lawyer vis-a-vis a lawyer having the kind of expertise and having the kind of brilliance that Mr. Hundal has or Mr. Khaira has, because they have acquired everything through their experience, and everything is registered in the head. A younger lawyer would only have access to library, but would not have any access to experience. So with technology, what has happened is that the same judgments are now within the public domain. At the drop of a hat, at the click of a button, a younger lawyer will also have access to the same judgment as a senior lawyer would. What will ultimately happen is that how the matter will get distinguished when it comes to a younger lawyer arguing against a senior counsel is the experience, that what is it that you have to impress upon in the first 5 minutes of starting your arguments, which will weigh in the mind of the judge and will have an everlasting impact from which it will be very difficult to claw back. That is the experience which, as a younger lawyer, which I also learn. When I see all these people, the people I have always looked up to and I've always admired, certain things which I lack or I don't have as much in abundance as my learned friends have. When we watch, we observe, and then we see that this is perhaps what I should have argued in the first moment, and perhaps the second argument should have been my last argument. So I personally believe that technology to that extent has a great advantage here. It has a very big disadvantage also. Way back in the day, like in 2003 when I joined, so we used to have these weekly digests. And because we did not have access to computers, we would, at least I would, and I'm sure my learned friends also would, we would go through the digests, we would make notes of the judgments, AIR manuals, and then, see, most of the times, like 80% of the judgments are reiteration of the previous law. Very few times do judgments come which lay down new law or which are set a previous precedent. So we would make notes. I've still maintained that diary. After digitalization, unfortunately, and I have to be honest enough in admitting this, that intent of maintaining your notes has kind of evaporated. And, we would remember our judgments with page numbering. I mean, I still remember certain judgments. There was a judgment which my father argued that matter. That was a case reported as Gurjant Singh versus Financial Commissioner Punjab, reported as 2000 volume 2 PLJ page 7. I remember that. Now, there is this one judgment which I believe all of us have heard about. It is SMS Pharmaceuticals versus Nita Bhalla. It's a 3-judge bench judgment of the Supreme Court on Article 138 of the Negotiable Instruments Act. It's reported as 2005 volume 4 RCR Criminal page 141. 2. I would see Justice Singhvi in court number 12. And Justice Singhvi would start dictating judgments and he would start saying on natural justice reported as AIR 1961 Supreme Court, etc., etc. I was like, wonderful, what a brilliant man. What a brilliant man. He remembers his judgments with the page numbers. You will notice this with a few judges of the High Court. A latest example that I would actually point out is Justice S.P. Sharma. Whenever you will see Justice Sharma dictating a judgment, he will remember the page number of that particular judgment when he dictates it in court. I hope that we get back into at least that routine where we make notes. We are abreast with judgments. We read judgments. We have stopped reading judgments. I would request all of you, please start reading judgments. My foundation is, and all of our foundations is, the style in which a judge has written a judgment is the best language. We don't read it anymore. We only end up concentrating on head notes. Please stop doing it. Read a judgment. That man who's writing a judgment has at least 30 years of experience, which has got crystallized into that judgment and the words that are being used. Please start reading that. It will make you better lawyers. It will make this profession even better. And perhaps it will really help us in getting justice for our clients, the very reason why I believe all of us decided to adorn this robe and wear the band, which we all should cherish very, very dearly and closely.
Thank you.
Thank you.
With great love and respect to my mother is a senior member of this bar and she joined this August bar in 2001. So she was telling me an instance in 2002 while Mr. Chopra was arguing a matter with some junior. And I don't know much of a Punjabi words, but he came outside and he said, "Oi, tere te na a judgments applicable ne." And my mother still tells he was kind enough, he took out that judgments and said, "Ye la judgments aap mere khilaf use kar." So a great respect to you, Mr. Chopra sir. Thank you so much, and you are leading that legacy very beautifully.
Very big shoes to fill.
Thank you. Thank you. Now we have our next speaker, Advocate Shri Abhimanyu Singh. Sir has done his LLB LLM from Kurukshetra University. He did enroll with the Bar Council of Punjab and Haryana in 2010 and has a vast experience of about 10,000 cases in last 15 years of practice. I see him as one of the humble and most hardworking advocates I have ever met. A very brilliant criminal lawyer, always helping young lawyers. That you can use this judgment, these judgments. Among his peers also I have seen, and I hope that he becomes an esteemed jurist of the bar. Sir, and now I request you to please say your insightful words on this very topic.
Good evening, senior members and my dear friends. Today we have a topic which cannot be, research cannot be made on the said topic. Only experience can tell what is going on and what has happened in your, career. As far as my experience in this field is concerned, I started here in 2011 with my uncle, and thereafter, in 2012 only, I started my independent work also. See, what I feel, and I'm sitting with the 3 senior counsels of this esteemed bar, a person who is having a good work, only he can interact with them. Otherwise, all other members, and I think I'm speaking on behalf of all my friends, I think most of us are not having the opportunity of even interacting with the senior lawyers because we are not having that much of work. So it is, sometimes we personally feel that if we don't have work, we cannot interact with the senior lawyers because the system of our, bar is like this, and we are into mechanical approach. We used to come here, we used to do our matters, again go back and sit in the office, and every day 5-day work is like this, and Saturdays we all used to go to the district courts for procuring work and all. Right? I think everybody agreed with this. So as far as this lacuna is concerned, I would request all my friends also and my senior members also that such like sessions should be in routine so that we can sit and we can discuss these issues with each other. Because the difference between the senior and junior is increasing day by day, and the respect, no doubt, we all are having respect for our seniors. Every time we are trying to interact with them, to discuss few things with them. It is not a position that every time they are not helping us or they are not welcoming us. But most of us are, they all are not having that much of work that they can interact or they can engage the senior counsels in their matters. As far as the other topics are concerned, like the new role of technology, like in today's world, when the technology is improving day by day, and we all are, if we will only stick to the books and will not adopt these, the latest technology, we cannot, do much in this profession because ultimately the time is less because only we have like 6 to 8 hours in the court, and thereafter we'll have to do drafting work also, we'll have to do research work also, and then we will have to communicate to the clients also, and we'll have to, give satisfaction to our district court lawyers also. So ultimately, there is no other option except to adopt the new technology, and we all are trying to, communicate with the other. See, in my office, I am having a good battery of team, and I always, rely upon them. I always try to give work to them so that they can also learn, and I request the senior members also that each and every time, because we all can understand that a senior lawyer can only appear in the matter where he has been, stakes are high, and he has been, specifically engaged for that very purpose. So, but in normal offices like we have, we can give chances to the lawyers, the junior lawyers also, so that they can appear, they can learn, and they can take the confidence of appearing in the bar, before the honorable judges also. Thank you.
These days, sir, the difficulty is once a young lawyer is pursuing his point before the judge, at times you see that judge gets annoyed कि जी ये मुझको बताएगा. See, a lawyer may be wrong in way of his pursuing on a point because he doesn't have that experience to express himself. Obviously, he may not have that much knowledge as judge has, but then you are getting a thrashing, you are not getting a nurturing. This is something very prevalent these days. जैसा आपने शुरू में कि जज को नहीं पता तो सारी किताबें लेके जानी है आपने. You may be knowing that point, the judge may not be knowing point. कैसे कहते कानून तो एक अथाह सागर है. तो everyone may not be knowing everything. तो हो सकता है वकील को तो पता हो पर जज को भी ना पता हो. But once a young lawyer tries to pursue his point and make a judge to understand it, he gets annoyed and he is snubbed or she is snubbed by the bench. How to deal with it?
We had been carrying books to the court to show to the court that I have read the case, I have prepared the case fully to hammer your point. Mr. Nupam Gupta, he does it. Long line of, today he is doing it.
Yes, he is doing it.
He will bring 50, 40, 30 books to courtroom.
It is only he who is doing it, sir.
It's not a bad
But
habit.
it's not bad, but आप judgments लेके जाते हो तो it is hardly
नहीं,
judgments are
but you will
appreciated.
find judges, I have experience of it. If you wanted to have a date, carry 10 books to the court. The judge will put a date.
But judgments को तो appreciation होती नहीं सर. आप इतनी मेहनत करके लेके जाते हो, hardly it is appreciated. These days it's a disposal only.
You know, that's also learning. It's not that it's only, whatever your point is, very valid point you have. We notice this daily. We have also gone through that phase, at least I have. But even as seniors, you still at times have those situations where the judge would not want to listen to you after a point. Right? The only difference is that perhaps a younger lawyer might get 1 minute of audience and a senior counsel might get three minutes of audience. Right? But that's also learning. The learning is that in case the judge, for whatever it's worth, see, first of all, we never compare ourselves with judges. We should never. We respect the pedestal at which that judge is sitting. We respect the chair. That respect should never ever be diluted. That respect should never ever get whittled. Because the day that respect goes, this institution will crumble. It is built on respect and mutual regard for each other. And so the learning is that in case you might think that the judge has not been fair on that day, has not given you audience, etc., etc., whatever it might be, never lose your cool, never lose your patience. That's also a learning. I personally believe that that's also learning. People might not agree with me, but the fact of the matter is that the majesty of this profession cannot be allowed to get diluted by getting into a mudslinging match in open court. No. I've noticed that also unfortunately happens where limits are crossed. I never encourage it.
But the golden rule is, an advocate may lose his case.
Never
you must
lose
not lose your client and the court.
Yes, absolutely.
So one should be very, very respectful to the court and to your client also. They will come to you time and again.
I hope, parting, I will suggest something. Why all this has happened is interaction between judges and lawyers has stopped. In Sarkla meetings, I have twice suggested to Chief Justice of India that there should be discussion beyond the courtroom, where you can talk strictly on merit and it is not taken that you are pleading for your client, not what exactly is. This interaction used to be there. Now they would say, yes, this is a good idea, but would never implement it.
That's true.
That interaction is very necessary.
Bar Council, 1997.
I should have mentioned.
No, it's all right, thank you.
And so in addition to the questions that we have, so I would like to have your all thoughts on the role of young lawyers in assisting the seniors in adapting to technology and artificial intelligence. So please share your thoughts.
So this question
No, seniors have nothing to teach juniors when it comes to adapting.
We have to learn from them.
Oh, yes.
There is a joke. I said can't find it on telephone, and what I get in return is ask your granddaughter, she will do it.
Very right, sir.
They learn it more quickly.
Any other questions from anyone?
Sir, I would like to know any kind of advice that you would like to give to the Bar Association, because obviously we have led the Bar Association for our esteemed bar. So any advice on your part to them that how they can help to bridge this gap between the generations, between seniors and juniors, and have more interactions other than the courtrooms?
By having these interactive sessions,
Like this.
as sir had mentioned. This is a wonderful initiative, and similarly such initiatives should be increased even more. It should be encouraged, and I'm sure no senior would ever say no to having these
Yes, sir.
interactions.
No, this can be done by holding meetings in the bar room, meetings
Yes.
of bar association. We have forgotten everything about meetings.
No.
For years together, the bar does not meet. There should be, after every 2 months, there should be a meeting of the bar. Speakers should open up their minds.
And instead of mudslinging, we should discuss the basic issues.
Yes.
Why there are areas?
and I think the
Why
fulcrum
the
of the,
disposal is so little? Reason is, a lawyer who becomes a judge who has never filed a bail application, he is asked to decide a murder matter. And one who has never done an RSA as a civil lawyer is fixed for RSAs. Earlier there used to be, when service matters just started, Justice Tully was the judge who will get all the service matters in his court. And we used to tell earlier days, Kuldeep Singh, Mangat Agnihotri and Jawaharlal Gupta, they are re-employment lawyers.
So you must impress upon the president and secretary.
This
to hold
practice
meetings of the bar
of changing
after
benches
every 2-3 months.
yes, sir.
started because certain chief justices had a doubt that there is court bargaining, finding the proper court where you can get relief. To avoid that, they started changing in that also. But it has resulted in lots of areas.
You're right, sir. Thank
I
you.
won't name, I know a judge who was frank enough to say in the court, I have never done an RSA. So both of you be prepared, don't get a wrong judgment from me.
I have every time we lawyers give speech, we start that lawyers have created freedom movement and we are freedom fighters. But since I have joined the profession, I have never seen a bar association discussing any issue related to society or to the country or even to the legal profession. For example, this new law was amended. No discussion in the bar whether there is any need to bring out the new laws. Now, with regard to the amendment of Advocates Act, there is no discussion. Third, the recent yesterday issue with regard to this parking and destruction of this wall of rock garden. We have destroyed the entire forest area beside the rock garden. We have destroyed the entire forest area in front of it. Now we are planning to carve out the road through this, directly from this. The issue relating to society, we never discuss, we never take stand, we never issue a single statement.
In good old days, we have been doing it.
Yeah, during emergency,
Yes, sir.
we were the first bar to pass a resolution against substantial judges. And I know how it happened because I moved that resolution.
In every speech we remember our legacy, but we do not do that.
It's a very good suggestion.
It should be encouraged.
Questioning of interaction, you will find this happening. Things don't happen and files don't move. This chambers, there was a plan approved everything, no funds coming. Kiriwala was present, I said, let us go to Barnala, get a letter from MLC Finance Minister. It was made. Now there is a approved plan for multi-level parking where we park vehicles and even 2 floors for chambers.
sir, I-
But because funds are not provided, I have been suggesting that through the local MP, earlier it was better, it was a BJP MP, that we propose and get a letter written that provide funds, they will be provided.
No, sir.
Because file must move for that.
Sir, I'll slightly, why, because I am involved in that litigation again. Sir, this proposal, in fact, I have to compliment Honorable the Chief Justice for the last 6 months.
Yes.
Has been doing you see the order that I passed. The problem is, way back, I think this Capitol complex, including the first High Court building, the originally designed High Court building,
Yes.
this is a UNESCO World Heritage Site. Now, you cannot carry out any changes in the periphery of that of this building without seeking the prior permission from the World Heritage Center under UNESCO. What had happened is that we had the High Court on its part had prepared what we called a High Court Holistic Development Plan.
Yes.
The plans were approved, the sanctions were granted, so running into 350 crores odd. It hit a bottleneck when there was a judgment of the High Court, the division bench judgment of the High Court regarding Sukna Lake catchment area. So then the UT gave an affidavit saying that because the High Court now has passed a judgment that there can be no construction in the Shukna catchment area, that is the reason why we cannot give approval to the holistic development plan. To buttress that argument, then they got a report from the Chandigarh College of Architecture. What did that report say? That whatever was the plan under the holistic development plan, if that comes up, it will adversely affect the heritage structure, the quality of the High Court. Thereafter, and I am now taking names. So Justice Sandavalia was there when he was acting Chief Justice, Justice Ritu Bali was there when she was acting Chief Justice. Then they said, we will not agree with this report. Then, on the asking of the High Court, the centre then made a statement, filed an affidavit that they will get an independent assessment done from IIT Roorkee. Unfortunately, that report which comes after 1 year, 1.5 years also says that in case this structure comes, it will adversely affect it will have an adverse effect on the heritage status of this building. So everything has now collapsed. Even that multi-level parking can't come up. Even the development of this green kacha parking, that cannot come up. You will be shocked. Some of the courtrooms here, till court number 69, they fall within the catchment area. That is now the report which has come
From the IT road.
in the High Court judicial side proceedings, that some of this area is Sukna catchment area. This is illegal.
But should I say something?
Sir.
I want to know one place in the world where construction is bad in catchment area. One place in the world except this.
Sir, of course, that's a judgment which we have to follow. There's a review
Nonsense going on there.
No, I agree, but sir, why we
Let
can't
me
comment?
one place in the world. There are cities around lakes.
You're right, sir.
There are cities
Around.
human started living near the rivers.
You're right, sir.
It's
And
without a water body, human being
all the
couldn't
European
exist.
countries
There was another thing that the foundation of the High
Second,
Court
second.
was laid
This is
Before the
there is a false
Yes, sir.
assertion. No water flows into the lake from this side.
absolutely right.
Second, construction doesn't stop flow of water. It increases because it stops seepage. But I don't know how unscientific they are.
But sir, unfortunately, that is the ground reality.
But our High Court traffic problem cannot be solved if we cut even every single tree.
You're right.
You tell me.
If we did not regulate,
Lake is also
if we did not discipline
The
our
Courtroom is on that side. Only 4 point is on that side.
Yes.
From this side, no water flows.
Sir,
And it flows into exactly sector 4.
Sir, ultimately, we might have a difference of opinion regarding the judgment. I'm absolutely agreeing with everything that you say. But the thing is that if there is a judgment, till the time the judgment is not reviewed, it binds us.
I find the review where it was.
You are the one who won the stage.
Thank you, sir.
judgment was right.
So due to paucity of
Chandigarh only
time,
has
we
this
ended here.
That only differentiates.
Nobody has
That's
seen
another
what
matter.
is there.
Genuinely requires a discussion. Genuinely requires a
We
discussion.
do need
Let us
space,
move now.
we do need.
It
But
will
it will study.
require
This vote of thanks.
technical studies.
We'll end.
Yeah.
Haryana ki row was diverted.
So
Or
that-
did I ਜਜਮੈਂਟ ਸੁਪਰੀਮ ਕੋਰਟ ਦਾ ਸੀ ਦਿੱਲੀ ਹਾਈ ਕੋਰਟ ਦਾ ਰਿਗਾਰਡਿੰਗ ਟਾਟਾ because that was being built in the area where the flow was there, not kilometer this side.
Enough is enough. Please do it.
So we are fortunate enough to be joined by so many esteemed members of our bar. And now I would like to thank Honorable Chief Justice Mr. Sheel Nagu, who has always encouraged us to indulge in such discussions and beautiful sessions. We are grateful for his wisdom and invaluable contributions for this event. I am also thankful to Advocate Suvir Sidhu, Member Bar Council of India, for organizing such a thoughtful event. He has always been a guiding light to each one of us in planning these events. Most importantly, thank you all for joining us in this beautiful session and making it a success. Thank you everyone.
Thank you.